Hello and welcome to this event, Women in the Law, as part of Victorian Law Week. Thank you all for joining us. My name is Randa and I'm a self-represented litigants case manager at the County Court, and prior to that I was the associate to the then Judicial Registrar Tran, who is now Judge Tran, and Judicial Registrar Burchell. I would like to begin by acknowledging the traditional owners of the land from which I am speaking, the peoples of the Kulin Nation. I pay my respects to their elders past, present and emerging. If you have any questions today for our panellists, you can type them into the Q&A box at any time during the event. I will relay the questions to the panel later on when we have some live question time. I'm pleased to say that we've had 500 people register for this event today, so we may not be able to answer every question that comes through, but we'll definitely try. Our panellists today are Judge Sexton from the Criminal Division, Judge Hampel from the Criminal Division, Judge Tran from the Common Law Division, Judicial Registrar Burchell from the Commercial Division, Rachele, who is a Criminal Division lawyer at the County Court, and closest to me, Rachele Waters, who is also a Criminal Division lawyer at the County Court. I have a couple of questions for our panel to start the conversation. We will take live questions shortly, as I foreshadowed, but please feel free to type any of your questions into the Q&A box at any time. May I please remind everybody that our panel is unable to provide legal advice or comment on specific cases. So if I may start with you, Judge Sexton, what are the major changes you've seen during your career or lifetime regarding women in the law?
Well, thanks, Randa. If I could say that wearing pants was one that immediately came to mind, and it might come as a shock to some of the younger viewers that that was about the early 90s when women felt confident enough to start wearing trousers in court. But more seriously, the visibility of women in all areas of the legal profession, that's been the major change. And drawing on my own experience, when I was appointed as a Crown Prosecutor in 1995, I was only the fourth woman in that position in the previous 150 years of Victoria, and the previous three had been just in the 2 years before me. When I was appointed to this court in 2001, in the years leading up to 2000, there had only ever been 8 women appointed to this court. Between 2000 and 2006, 17 women were appointed. And so the percentage, the critical mass of women increased greatly, and that made a huge difference. That visibility changed the perception of people outside the court as well as inside the court about women reaching those parts of the profession. So that's been the real major change in my career.
Thank you, Judge Sexton. Judge Hampel?
I'm even older than Judge Sexton, so there were even fewer women practicing in the law when I started. There were so few at the bar when I started that they knew it was just my first name. So now we get our full name, and that to me is one of the real differences. It's no longer remarkable to have one woman in court. It's no longer even remarkable when the judge and all of the lawyers in court are women. That's been a big change. What that's brought about is not only the visibility that Judge Sexton spoke about, but a shift in the way people think about the role of women in society. Women's experiences can be different from men's, and so women judicial officers might have a different perspective on behaviour. Women lawyers might have a different perspective on behaviour and therefore put arguments in a different way. So that's been a big shift. And when you get critical mass numbers of women, it stops people being picked off as individuals because they're a woman and things they do being blamed on that or attributed to that, but rather it's a better way of showing that the representative views of society are not just always through a male lens. So that to me has been the big shift. The little things like the trousers, like people saying he or she instead of he every time they refer to the lawyer, the police officer or the expert witness has been wonderful. And the calling out of bad behaviour that we used to just have to put up with has been the other big shift.
Thank you. That's an absolutely fantastic point, Judge Hampel. These two women, I think when I arrived at the bar in 2002 were really, the heroes that I could look up to. So for me, when I arrived in 2002, I think my world was very different because I had female role models who I could see working in the upper levels of the bar, on the bench. Some of my first appearances were before female judges, which is an extraordinary difference. But I think what has changed since I arrived in 2002 in a big way is that rather than in 2002, where there was very much a confidence that women could do that job that men did just as well as men did, now there is a recognition that there are different ways of doing things. And I think that really jumps off on the point that you made, Judge Hampel, that there are different perspectives that can be brought to the role of a judge, to the role of a barrister, coming from that diversity of experience that we're now seeing coming through.
Thank you, Judge Tran. Judicial Registrar Burchell.
I think the big shift for me through my career was really in 2015 when Judge Tran and I were very privileged to job share the first judicial office in Australia. And that was really thanks to this court being very open-minded and progressive and very can-do. So now Justice Marie Kennedy of the Court of Appeal was our then head of the commercial division, who had that great foresight and courage to put that proposal to then Chief Justice Rosines and to the Attorney General, and that the profession was really welcoming about that concept, that because Leanne and I both had very young children but were quite senior juniors at the bar, wanted to have a more balanced life and to actually spend some time with our kids. And so we were able to have this job share of one judicial registrar job, and I was 3 days a week and Leanne was 2 days a week. And then as our children got older and the role crystallised and morphed into something else, we were able to increase our days, which was really important to our convenience and the court accommodating that. And then we eventually ended up, probably a couple of years ago, full-time. Yeah, it was a really great moment.
Can I just add something in that?
Yes, please, Judge Hampel.
You gave the credit for that to Chief Judge Rosines and to Justice Marie Kennedy. You two had the courage and the vision to make the joint application. But it's a really interesting thing that women are often much more modest about their achievements than men. And this was such a good example because you were the first. It was so groundbreaking. It was such an exciting thing in the court, and yet you're giving the credit to others.
Thank you, Judge Hampel. That's a very important point to make, and congratulations, because I think you've shown that it can be done, and it allows other women, I think, to have the courage and the strength to ask for similar arrangements in the future. So thank you.
And that helps everybody.
It does.
It helps women, it helps men, it helps everybody to see that there's other ways of doing things.
Absolutely.
We don't have to do the way that things were set up back in the time when men had a wife at home. Basically.
And when women at the bar who had children weren't allowed to talk about it because people would think that they weren't serious about being barristers. So suddenly having a family was just part of life and didn't mean you weren't serious about your job.
Yeah.
Thank you very much. Rachel, would you like to inform us on what you think, the major changes are that you've seen during your career?
Yes, I've been working for about 10 years in the law, and I think sort of for those first few years change, it seemed quite slow, but then I think the law, just like greater society, has had its own Me Too movement in the last couple of years. And to me, that's, the investigation into a former Justice of the High Court, investigation into sexual harassment in the legal industry and in the courts, has all happened really recently. In that last sort of 3-year period. And I think it's really shown me as well that change, will reflect society, and change is not always linear. So we've had a very quick progression of change, I think, in the last few years.
Thank you. And Rachel, would you like to add anything to that conversation?
I mean, I think the panel has pretty much covered the majority of the changes, most of the changes. I would echo Rachel about the cultural change. Again, I've been in the law for about 10 years as well. And I would say these days, outdated views are not necessarily the norm. And also, as I think Judge Hampel said, it's being called out more. And I feel more comfortable myself calling outdated views out than 10 years ago. I would have felt like I was being a nuisance or annoying, that sort of thing. I would say there's more, as Rachel touched on as well, there's more processes in place, and that's being communicated to the profession. So if there are issues, we can reach out and speak to the appropriate people. And just from my experience, I believe that women are supporting each other more, even more. I know they were in the past, but we're realising that we're stronger together.
Absolutely. And I echo that final sentiment because I am an absolute beneficiary of that support with Judge Tran and Judicial Registrar Burchell mentoring me and taking me under their wing, so thank you. So if I may come to our second question, please, for the panel. For the women who are involved in court cases, so the judges, but I also think the lawyers work on some of the court cases, if it's an accused or a victim, do you think there are things that are different for them now when they come to court compared to a few years ago or a decade ago?
Well, perhaps if I'll jump in there, Randa, in the criminal division, the majority of criminal trials are sex offences cases, and the majority of the victims of that alleged offending are women or children. We have had some massive steps forward in the last 16 years in particular, and even more so in the last 5 years, that have made it so much easier for them to give evidence in what is already a very difficult thing to do, having got to that point after reporting their experience. So I just want to run through a few of them for those of you who may not have heard about this, but the default position is for an alleged victim in a sex offence case and some other associated types of cases to give evidence outside the courtroom and to be coming in audio-visually so that they can elect to come into the courtroom, but they are protected by that mandatory provision. You do not have to be in court. Your evidence is the same where it's heard in the court or in a separate room over an audio-visual link. Just recently, we have had, in the last 3 years, the intermediary pilot program, which provides for women who have a cognitive impairment. It also provides for children, but concentrating on women for the moment, as this panel is. They have got the capacity to be assisted by what is called an intermediary to enable them to understand the process, to understand the questions they're being asked, and for the court and for the jury listening to them to understand their questions. And that might be an impairment that is physical, that makes them difficult to understand, but it may be simply an intellectual or cognitive impairment, which means that they are just really finding it very difficult to listen to in the area of stress to the questions. There's also pre-recording of evidence, which can reduce their stress, and that happens with both women with an impairment and children, but also for any appropriate case, we can make that arrangement. And finally, there's been a child witness service now in existence for about 14 years, and whilst that deals obviously with children, it alleviates a lot of stress on women who are secondary victims, if I can put it that way, when their children are alleged to have been involved in cases as victims. And the final thing I wanted to say is that we've also changed what we say to juries about the nature of sexual offences cases and how to deal with the evidence that they're hearing. They have been massive changes just since 2006. We've got a lot more work to do, but I just feel, when I look back how far we've come, I feel really gratified that the justice system has been able to accommodate women in this way. But as I say, we're still working on more.
Yeah, such important and difficult work that you're doing, and hats off to you.
Thank you, Judge Sexton. Judge Hampel, before I throw to you again, we do have a live question, and I think this live question actually ties in well with what we're discussing right now. So if it goes over some of what you've already covered, Judge Sexton, I apologise, but if there is something in addition that you can touch on, Judge Hampel, please do. So we've got Philomena who says, how can the courts be reformed regarding sexual offences cases, which I think we've just touched on. For instance, the process being less harmful to women victims, so we've addressed some of those examples, and ensuring those guilty of child sex offences involving multiple victims over extended periods receive more significant sentences. Do the courts require more education regarding victim impacts?
Look, the Royal Commission on Institutional Responses to Sexual Abuse of Children, I think, was a confronting thing for the community at large and for our jurors. For those of us who are judges in the sexual offence field, much of it we knew, but this crystallised and brought it together in a much more comprehensive form and allowed proper research and data rather than anecdotal responses. So that's helped inform some of the changes that we've had, and also made us think harder about some of the reforms that we'd introduced and whether they were going far enough to balance the protection of complainants or victims as they gave evidence, understanding the concern about re-traumatising them, but also balancing it with the fair trial rights of somebody who said, I didn't do it. And that's always been a really difficult part for us. Because we're not the decision makers, we preside over the decision making, and an accused person must have the right to properly challenge the evidence as they do in any other case. But how you do that without allowing outmoded and outrageous assumptions about women and children to pervade the value systems of those who are asking the questions, as well as the value systems of those who have to make a decision, has been a really confronting thing. So what can we do? We're looking still at what more we can learn from the learnings of the Royal Commission. The Victorian Law Reform Commission has yet another reference on reform of sexual offence law. There's been one every few years for the last 30 years. And each one brings in reforms, and then they're evaluated and more reforms are brought in. The Law Reform Commission is looking at it again. We've got a court consultative group called the Jury Directions Advisory Group that looks at how we can improve the directions to juries and the general knowledge that there is. And we're also looking at procedural things, how to improve police understanding and attitudes, how to improve the questioning of people, and whether we can pre-record more so that people can give their account once early on and then put it behind them. But all those have to be balanced with a fair trial right, and where we work in a justice system where the prosecution has to prove its case and prove it beyond reasonable doubt, and the accused doesn't have to prove innocence. So we start with that presumption of innocence. The other changes, I think, are a lot to do with education, but it's not just education of judges. We have a lot of education that's improved enormously in recent years, but we're humans and part of our broader society. We're reflecting some of the attitudes we grew up with or we changed, or we've come to think of differently as we've grown up and been exposed to what we are. But we also need much better education about the reality of the phenomenon of sexual abuse for prosecutors, for defence counsel, for police who are doing the investigation, for forensic examiners, and for people who serve on juries who are reflective of our broader society. So, of course, more can be done. And the stories we hear of individual cases where people have been re-traumatised by going through court fill us with horror, because we want to be part of a justice system that sends everybody away thinking there's been a fair hearing according to law. And if we don't do that, there's a failure somewhere. Some of it's also legislative. So it depends upon Parliament changing the law. We are bound by the law as it is, and the law as it's interpreted by the courts above us. So it's not just education of trial judges, but education of appeal judges all the way up to the High Court, and it's education of the broader community. Unless we keep on learning and wanting to learn, wanting to be better, that we're not doing our job properly.
Thank you, Judge Hampel.
If I could just add to Judge
Please, thank
Hampel's
you,
comment,
Rachel.
prior to coming to the court, I was with the Office of Public Prosecutions, and just from a prosecution perspective, I know that there's been a lot of work done as well in addressing victims and better ways for the prosecution to deal with victims. There's been some new legislation introduced about understanding victims and how the prosecution officers keep victims informed, take victims into account to ensure that they're being heard by the prosecuting agency as well, not just the courts. There's been a lot of work as well done. There's a witness dog as well that's been brought in by the Office of Prosecutions. So there has been a lot of work done on that prosecution side as well. But of course, there's definitely a lot more that can be done, and I know it's still an ongoing process looking on how those processes can be better.
Rachel, some of it's the trauma-informed practice that they
Yes.
talked about in the Royal Commission into institutional sex abuse, and they're using to inform the work in the Disability Royal Commission to the trauma-informed practice, how to understand how traumatised people will respond to trauma and how they'll give an account, and therefore helping understand from their perspective how to help them navigate through the legal system. There's been a big change in the last few years. We're probably still just starting to see the effect of that. But, we're learning from other disciplines. I think that's really important.
Yes, thank you, Judge.
Rachel,
Rachel,
Rachel.
Thank you, and Rachel, thank you. That was an important contribution to the conversation. Before I ask Judge Tran and Judicial Registrar Burchell about their experiences with women involved in court over the last decade or so, Rachel, would you like to add anything to the criminal sort of aspect of this discussion?
I think it's been pretty much covered. I would echo Judge Sexton saying the legislation changes that have come into place, so processes can change with complaints giving evidence from a remote witness room, and also again the culture is changing a lot because of the legislative reform that's coming through. So you no longer see barristers slamming their hand down on the bar table when cross-examining a complainant. There's always more work to be done, and it is traumatic, but it has come a long way, the experience of the complainants, as everybody's discussed.
Thank you. Judge Tran, would you like to provide us with some insight about your experiences with women involved in court? And do you think things are different for them now compared to, say, a few years or a decade ago in sort of the commercial or the common law sphere?
Sure. I mean, it's hard to follow on from that because obviously when you're talking about victims of crime, it's so important. But in civil claims, which is where I work exclusively, there's all sorts of players that are involved in any court case. So we might have expert witnesses, we have the barristers, we have the solicitors, we have the witnesses, we have the plaintiff, the defendant, and any one of them could and ought to be female. Certainly in the past, it may have been that a woman might come to court as a plaintiff, for example, saying that she suffered some injury, and she would be confronted by a male judge, male associates, male experts, and male lawyers. But now that picture is very different. We are seeing female expert witnesses. We are seeing increasingly female barristers, female solicitors, and as always, female litigants. And I just think that diversity of experience and the diversity of voices is helpful at the end of the day in determining the facts of a case. Because without that diversity of experience, it can be hard to understand really where a particular claim is coming from.
Thank you, Judge. Judicial Registrar Rachele?
So in a commercial sphere, we may see the use of some of these tools in judicial mediations. So safety is really important in circumstances where we have women who have IBOs out against some of the plaintiffs or co-defendants, usually wives and husbands or exes, boyfriends, other family members. So we have to be quite sensitive to that power dynamic, and when we have participants coming into the court to ensure their safety, and that requires the judicial mediator to have some training as well. So from the Judicial College, attending things like the restorative justice, suicide, and mediations where you work on tools of acknowledging power dynamic and acknowledge emotion and vulnerability. So we try and ensure maybe some techniques would be not having a joint session, particularly if you do have those IVOs or if there is an unconscionability claim or duress claim, the Eukin Jones type example where the husband has overborne the will of the wife and signing up guarantees, loans, etc. So we might utilise now video conferencing, such as what Judge Sexton has referred to in the criminal sphere in a judicial mediation, or to ensure that the participants are in separate rooms and that security is alive to the fact that we have these sensitivities on the ground, and to make sure we've got our duress alarms and panic buttons available, just to ensure that everyone is there in good faith and trying to equalise any instabilities or inequalities in power.
I wonder, Randa, if you might have something to add to this topic, because you work very much at the coalface, providing assistance to litigants who do not have representation by lawyers.
So at the coalface, I think, we have both men and women who are self-represented litigants who require assistance. But the issues that I think the self-represented litigants face are probably quite similar across the board. There are a couple of instances where, similar to Judicial Registrar Burchell, there may have been cases potentially of unconscionability. So because we are open to sort of some privileged information, sometimes we can use our discretion to liaise with the judiciary to signal that there may be some merit in a pro bono referral to the Vic Bar or for a judicial resolution conference, just to help even up the playing field. But generally, I think the self-represented litigants face similar issues across the board. There are instances where there is a particular issue or potential issue of unconscionability that we can foreshadow and address, but generally those issues are the same. But what I have seen is, despite how much, in law school, women potentially outnumber men, or it's 50-50, the numbers aren't reflected necessarily in the senior ranks in the profession. But as an associate, when I came on, I noticed that Judicial Registrar Burchell and I celebrated one day, because on Zoom, when we were doing a directions hearing, it was all women. Counsel, instructors, the associates, and the judiciary. And so, and that actually in the commercial sphere, you might have a half-half, but the fact that we celebrated and took a screenshot, and that we still haven't quite come far enough.
Yeah, that's interesting, because I sat in commercial with a judge in about 2012, and we lamented that in 6 months of commercial we didn't have a female barrister appear in front of us.
Wow. Yeah.
So that's definitely shows that it's changed.
Yeah. You've got a delightful story to tell about that, haven't you? About a photo opportunity.
Oh yeah. Well, no, I've forgotten the serendipity that is going to Registrar Burchell as well. When I was still at the bar and I was a silk, I was doing a case in the federal court, and I was opposed to Marie Kennedy, who was then a silk, and who's now came to our court and is now Justice Kennedy in the Court of Appeal. And we were appearing before Justice Sue Kenny. And when I walked into court, and Marie and I both had boy juniors, but when I walked into court, there was a photographer there, and I was sitting there idly saying, what's going on? And it suddenly occurred to me that it was because it was a case with a female judge and 2 female silks leading. And then Sharon Burchell was the associate. 2003. Yep. And again, it was something that was marked because it was historic. And we were sort of excited, but also hoping that we would get to the day where it became commonplace. As it has in crime, we quite often have in crime now a female judge, female barristers on both sides. Sometimes a female police investigator.
Great. Thank you very much for all your insights. So I think this leads us into the next part of this event, where we're going to take some live questions. We have received we've received a few live. There is one question which I think segues into something that we were going to touch upon. So if I may start with Judge Sexton and Judge Hampel, it relates to the recent review of the sexual harassment in Victorian Courts report that was recently published. As senior judicial members on this panel, what are your thoughts on this report? And if I may also just tie that in with a live question that we have a mature age law student who said they pivoted into law in their mid-40s. They've been shocked at the revelations and allegations of sexual misconduct from senior male members of the profession. Do these allegations come as a surprise to the panel? And is this a moment of real reform for the law profession in Australia?
Again, you start.
All right. Well, I think at the risk of being boring, I think we will all be very careful not to express any personal opinions about this, because we have been really well guided by the heads of the jurisdiction in the state of Victoria who have issued a joint statement about the sexual harassment review. And amongst other things, so that's the Chief Justice, the Chief Judge of this court, so Chief Justice of the Supreme Court, Chief Justice, the Judge of this court, the Chief Magistrate and the Head of the Coroner's Court and the Head President of the Victorian Civil and Administrative Tribunal. So all of those people have said, amongst other things, that they recognise that there has been this problem, that we acknowledge that our organisational responses to date have not been good enough and that we must and will do more. But we also recognise that we have already started working on this. Before this review came out, there was already a recognition of this being a problem. It may not have been quite as known as how widespread it was. And we're talking across the profession here, not just about the courts, but the courts are picking up the ball and running with it insofar as we're concerned. So I can tell you that as a result of the review and the report, that the Court Services Victoria, which is the body that handles the administration, if I can put it that way, for all of the courts, has set up a particular project team for the sexual harassment review, and each one of the courts and tribunals will be having input to that. And the County Court, which we are all members, will itself have a working group with some judicial members, but also members of staff from all levels. So again, recognising that it is important to have this as not top-led or bottom-led, but a joint approach to this issue. So, as I said, not talking about any personal experience, but just that we recognise that this is an issue and must be addressed. I think it is clear that one of the other aspects is that processes have to be in place so that we know this occurs. We must make sure that women feel comfortable in bringing their problem forward. So one of the things that was suggested was an anonymous portal, because people want to report it but not necessarily want to have something them made the focus of attention, but they want people to know about it happening. So that's just one example of things that we'll be looking at. But clear processes need to be put in place to make sure that women listen to when they want to be heard.
Thank you, Joseph.
So before I came to the court, I was at the bar for nearly 25 years, and a lot of my work was in the anti-discrimination and sexual harassment field. And I remember being shocked as a young barrister to discover my first sexual harassment cases and to discover what was happening in the wider working world. More shocked to discover the responses of people in authority in companies and organisations and industries, because so many men in power just thought this was okay and took it for granted. I think I was shocked by the Dyson Hayden allegations, and I was shocked by the outcome of the Zoki report, only because I thought things had changed and got better. They have in some ways, because there was no longer the sniggering, it's okay, or get a sense of humour, sort of responses that existed in the broader community when I was doing this work as a barrister. But I just suppose I had a hope or a trust that as women had gained greater equality in so many ways, that this behaviour was being reduced. I think what the report shows is it's not so, it's a bit like sexual offences in a sense. It's not so much about sex, it's about power and power imbalance. And to discover some of the structural power imbalances that still allowed attitudes and behaviours to exist was a matter of shock and, for me, of shame. I'd like to think that all of us are better than that. And I think any male colleague of mine or male barrister I know who I looked at me, I would say, this is terrible. But sometimes people don't explore their own behaviours or attitudes enough. That's not making excuses, it's unacceptable. But it is disturbing that it's still existing, and the values that inform people's attitudes allow it still to exist. I hope this is an absolute line in the sand moment. I think we've got a rare opportunity to be able to say, we can all do much better, and we should.
Well said. Thank you, Judge. If I may shift topic for a moment, we have a question that says, how can we make room for First Nations women's voices in the legal sphere? Would anyone like to answer that?
It's almost presumptuous of us to do so, isn't it? I mean, one of the issues that First Nations people keep on raising is other people speaking for them. But there have been a number of Aboriginal justice statements and restatements that the courts and tribunals have adopted. So ensuring that we're making culturally safe spaces for people to come to court, whether it's as litigants, as parties, as employees, or as judicial officers. Listening, consulting. Our County Koori Court is a fabulous example of engagement with First Nations peoples, where they're informing our decisions rather than we imposing decisions on them. I'm very conscious of not being a privileged white woman giving the answers.
Thank you, Judge. And I can appreciate and speak to that as a Muslim Australian woman, and wanting people to talk to you about your experiences and your faith and your culture and your beliefs, and having your knowledge of what you are inform what takes place rather than it being put onto you. So thank you. If I may throw to Judge Tran and maybe Judicial Registrar Burchell for this one. So we have Anna, who says, it is encouraging to see more women in the law. Can you comment on diversity, not only in terms of females being represented, but cultural diversity being represented too? Are the challenges the same?
That's a really good question, isn't it? Yeah. I don't think you can ever say the challenges are the same, because the whole point is what we're talking about is a diversity and a diversity of experiences, and everybody has a different experience. Myself, I'm a woman. I'm also a woman with a culturally diverse background because my father is Vietnamese. And certainly what we are seeing is an increasing recognition of a need for diversity in all echelons of the legal profession, and the importance of that, because our litigants come from a diverse background and a diverse range of experiences.
Thank you, Judge. Judicial Registrar Rachele.
I think this is a really exciting space right now, and there is an emerging awareness about diversity and the need for the judiciary and legal profession to reflect society in general. I think the fact we have, I think it started with Magistrate Tran in the Magistrates Court, and then in this court we have Judge Miso, Pillay, now Judge Tran.
And Judicial Registrar.
I'm also from Asian Australian descent. So, and I think that having that representation is exciting for people in the community, just like they see in MasterChef, like last year with the noodle episode and the 5 Asian Australians in the Immunity Challenge. It was something that was a milestone for Australian society. And I think some 3 years ago, we had our first Asian Australians who were appointed silk. So there are these real movements and changes that are occurring, and I think that this court is also at the forefront of that change in society with the Diversity Committee that the Chief Judge is launching. Judges Pillay and Tran are co-chairing that, so you've got all sorts of layers of diversity there with the people on the committee. And the Victorian Bar are also doing some amazing work as well with their diversity committee and looking at various reports and in other jurisdictions as well to see what recommendations can be put into place so that in a practical sense there is real change.
Perhaps I could just add one thing to that, just from on a sort of a personal level, and I think this is in response to that mature age student who sent in that question about sexual harassment as well, is that if there's anyone out there who comes from that diverse background, yes, there are challenges. Yes, there are challenges, but don't hesitate. Don't hesitate to take that step, to get into the law, to dream big, because there are also opportunities and there also are amazing supporters out there, men and female, who will help you along the way. And all you have to do is ask.
Thank you, and I can attest to that. We have, perhaps I could throw to our two criminal division lawyers, the Rachels, and if you feel that you'd like Judge Sexton and Hampel also to add. There's a question from Lee that we've received, and it says, are women referred to diversion programs at the same rate as men? And do you have experiences with that, and would you like to comment on that?
I might leave this for Judge Sexton to answer.
Okay.
As your honour pleases.
So diversion programs, as we understand them, are found mainly in the Magistrates Court and the Children's Court, and not in this court. But I don't want to dodge the question by just saying that, because we do have two exceptions to that, but they are very, very new. So we really can't comment on the rate of referral because we have no data. So the first exception is the Drug Treatment Court that is just starting up this month, I think, and that is in the Criminal Division. And we also have had since January this year in our court the Court Integrated Services Program, which is a bail support program, which covers a whole range of things. And I just refer you to the Criminal Division part of the County Court website just to see exactly what that covers. But that enables a court, a judge, to have a few more options about how they might deal with a person in terms of while they're on bail, but also ultimately in sentence. And if I can just segue into answering the question also in this way, that when it comes to whether a person is suitable for a diversion program or the type of sentence, it's really important to recognise that sentencing in each case is unique. So it will completely depend on the individual circumstances of the offence and the individual circumstances of the offender. And I should add also the individual circumstances of the victim. Plus, around all of that, a criminal division judge has a huge body of principles that we have to take into account and weigh up, and there's no mathematical formula. So in the end, one of the things, though, that we need to take into account is the prospects for a person's rehabilitation, which ties into reducing the risk of them reoffending, so that the community is protected in future from any future offending. And that's where a diversion program or some other way of dealing with a person that will enhance their prospects of rehabilitation will come into play, because ultimately it's to the benefit of not just the offender but the community as a whole if we can divert them from prison and have them not reoffending because they have been sentenced in a different way. But there'll be a whole lot of stuff to come before you get to that final point. Just watch this space for data in due course about the rates of referral of women and men. Oh, sorry, one more thing I should add. Men are the vast majority of offenders in the criminal area. So as a result, of course, they get sentenced more than women. So there will be a different rate of sentencing, a different rate of referral to any programs that we do have.
Can I just add a couple of things? First is that when you come to the county court, you're in the big legal ring. The magistrates court deals with a range of offences, some of which are quite serious. But offences to be sent up to our court in the first place are more serious. And so the offences are generally ones that are more likely to attract a term of imprisonment or a significant community correction order. We're not going to have that many fines or dispositions. We are starting to make a bit of use of deferred sentencing, and that's been quite helpful. That's a form of diversion. But again, it's got to be seen in relation to more serious offences and therefore likely to cause more serious penalties. The other thing is there's a gender difference in offending patterns often. So the circumstances in which women will commit an assault are generally quite different from the circumstances in which a man will. The circumstances in which a woman commits a dishonesty or fraudulent offence, the sort that we deal with, are generally, again, quite different. And so, again, if we're looking at tailoring sentencing to the individual circumstances of the offender, why they offended, and what's going to keep them from reoffending, we need to look at those reasons for the offending in the first place and ensure that the programs or the sentences that are available are going to address the causes of the offending.
Thank you. I think I have one final question from the floor. Well, the screen. Well, again, I think judges Sexton and Hampel, because it says as one of the first women. So I think perhaps it's as one of both of you, not one, appointed as judges. Were there any attitude adjustments that you felt were required from the fellow male judiciary, and how did you deal with it?
Well, by the time I came, we didn't have judges' toilets, which were only for the men because our men had been judges, which was a feature, I think, when you were appointed, wasn't it?
Yes, it was. We're in a lovely building here. It's not new anymore. It's 20 years old, but it's still a fabulous building. When I started, we were in the old County Court building, which, yes, did not have dedicated female judges' toilets. But I have to say that maybe because I was at the beginning of a huge number of women, in the year that I was appointed, 5 out of the 8 appointments were women, so more than 50%. Whether it was shock or whether it was resignation, in all seriousness, I have to say I had nothing but support from the senior judges. And if judges thought it was a bit strange to have this young blonde thing turning up in their court as a judge, no longer as a barrister, they didn't say so to my face. So it might have been there, but they didn't say it. What I did get was people saying the women judges on this court have changed the atmosphere, changed the conversation, the way we talk about things, and even just the method of talking about things. It's much calmer, and that was terrific feedback to get.
Thank you. So I'm conscious that we've only got 4 minutes left, and we have one final question for the whole panel. Judge Hampel, would you like to add any brief comments?
No, I think we'll go to the last question.
Okay, thank you. There is a question in there for me about professional education programs on Islam and the West, and do I believe it would be beneficial for that to take place and to be provided through institutions such as the Judicial College? I'm not sure that institutions such as the Judicial College are the right forums for that to take place. I think education for all minority groups is really important, and I think we can all work together in workplaces to celebrate each other's diversity. Judge Tran and Judicial Registrar Burchell are putting on an in-morning tea for me tomorrow and asked if there were any other Muslims that would like to come along, and it's those small steps that really open discussions, inform each other about our differences and our diversity. It's about having the courage and feeling that you're able to share with your managers, with your colleagues, that you are fasting, that you do feel tired in the afternoon, you may need to start and finish early, and having open discussions that will lead to the next step. But there is certainly a lot of professional education that needs to take place. I think the fact that we're talking about it is good, but it has to happen. What the right forum is, I'm not sure, but we do need to have a lot more education, and I think it needs to be strategic, and it needs to be implemented across the board and not just ad hoc with a few people championing diversity. undertaking that. So if I may now throw to the last question of the day to the whole panel. If you could give one piece of advice for women who are interested in a career in the law, what would it be?
Why don't we start with our Rachel's first?
Okay. I would just say, just back yourself. I think we sort of touched on it before that women are so much more, like, they're so modest, and we always just feel lucky to be somewhere. We've got to say that those people are lucky to have us. You got to change. I think, just change the mindset to you deserve to be in the room where it happens, and you deserve to be paid what you're worth. You deserve promotions for what you're worth, and just to keep backing yourself at every stage of your career.
Great answer.
Very terrific. Well, that's hard to follow.
She took my material.
But I agree, definitely back yourself. There's no reason if you want to be in law that you can't be in law these days. And I would add, surround yourself with good people. That's, network, reach out to people. If you see a senior female lawyer, go and have a coffee with her, ask, get a mentor, that sort of thing. It's a lot more supportive these days, and you can do it.
Thank you. Judge Tran?
Rachel stole my material. Look, I would very much second that in terms of reaching out and finding a mentor. Nobody is ever going to be offended because you send them an email and say, gee, I really admire you. Do you have time for a coffee so I can have a chat? They might say, no, I don't have time for a coffee, but they're not going to be offended. So there's absolutely no harm. Reach out to people, have coffees, talk to people about how they got where they are, because, there's so many people who have gone before us now who have got so much to share and so much to offer.
Thank you. Judicial Registrar, Rachele?
I think women need to support each other rather than see each other as competition or undermine, because there are so many other people out there who will want to tear you down to get up the ladder. I think we just need to be kind to each other, and I think that gone are the days where there were some who thought I struggled and suffered, so you must too. There was a bit of that, but I think that we're now being a lot more positive and realise that we have, together we're stronger.
Thank you. Judge Sexton or Judge Hampel?
I'd say take a longer term view of things. You can't always win every battle along the way and every step, but sometimes having a perspective of where you started and where you're heading, and taking the setbacks as much as a learning experience as the successes is really important.
Thank you, Judge. I agree. Judge Sexton?
Well, all of those have been fantastic responses, and I suppose I can really endorse all of that, and only add this, that grab every opportunity that sparks your interest. You may not think that you're ready, but you wouldn't be asked if you weren't.
Oh, that's well said.
So that lends itself to a bit of imposter syndrome. And I think some of us, I've had conversations sort of informally, and I think some of us do suffer from that or lack from that as women, as diverse women. And you're right. If someone's backing you, take every opportunity, because one, you don't know what that door that opens will lead to. But also, I think for me, it's remember those people who opened a door for you, and make sure that you give back and you continue to give back what was given to you, and that's how we're going to champion each other. And if I could, before I just close, I'll just read a comment that we've been given. We've had a few thank yous along the way for answering questions, so you're welcome. Thank you for attending and for asking the questions. But we've had women are just so inclusive. Such a different vibe to an all-male panel. It's wonderful to know we have such role models and mentors leading this profession.
Oh, thank you.
Okay. So if I may close, we've got a couple of minutes to go. I'd like to thank everybody on this panel for their insights and their wonderful pieces of advice and sharing your stories.